All right, welcome back, students. Again, I hope everybody's doing fine in these sort of strange and different times. And we're still in contract phase. We got this video here and the other two videos, and it'll be those videos in which we will use as the PowerPoints for our next test, excuse me, which will be on Moodle. Again, it'll be timed. Again, I'm probably going to expand the time. I had a lot of people indicate that they didn't feel like it's enough. I'm not going to expand it a lot. And part of the idea is making sure I develop a test in which you're going to have to know some of the materials. You can't be looking it up, whatever it may be, or taking the time to look up a lot of stuff because you just won't be able to get through the test. All right. So with that said, let's kind of continue on in our second phase of contracts. We've talked about contracts in the sense of offers and acceptances and everything. And this section is going to be dealing with the contracts that need to be in writing, how contracts are completed and or discharged, and the remedies if somebody doesn't fully perform their part of the agreement, what we call remedies. All right, so let's talk about, again, written contracts, the elements. We have the offer. I agree to sell you my bike for $50. The acceptance, which is sometimes called the handshake. I agree to purchase your bike for that $50. We both have given consideration. I'm giving you the bike. You're giving me $50. It was all agreed to. That consideration was part of the initial deal at the time we made our agreement. Nothing illegal about selling a bike. Right? Nobody was inappropriate ages, too drunk, didn't have the capacity or whatever it may be to make the deal. Both people consented. Nobody held a gun to anybody's head or anything of that nature, right? Those are all the elements of contracts that have to be present in every contract there is out there in order for the court to enforce those contracts. There are some contracts that have to be in writing, and that's what we're going to talk about now, is those contracts that are required to be in writing. All right, let's sort of start with these some primary purposes of contracts. Again, I want to make sure, I don't know if I talked about it enough in the first section, so again, I want to make sure I go over it again. Me going over it again tells you it's going to be on the test, so make sure you understand these things. Again, the primary purpose of a contract is to make matters predictable. Everybody understands what their obligations are. Everybody understands generally what they need to do, and if they don't do it, what the consequences potentially will be. And there's a secondary purpose, and that's for the court to determine if somebody doesn't fully perform, what's the remedy, you know, that kind of thing. All right, so that's the primary purpose of contracts. I also want to make sure everybody understands that throughout all contract law, the court requires all parties to act in good faith. Let me give you an example of what I mean by acting in good faith. Say you have a football player out there, and you're an agent of that football player, and the football player says, look, if you give me a contract for $5 million or more, I'll pay you 20% versus 10% that I would typically pay you, right? But you've got 30 days to get that done. All right, and get it signed and the contract, everything all dotted on the lines and everything. Okay. I go out and I find a team who's willing to pay you $5 million. I get all the paperwork ready to go and ready for you to sign, right? The good faith comes as you will be ready to sign that when I get it to you, and you're not going to go behind my back and go to that team and say, hey, actually, I will, if you agree to pay me $4.95 million, I'll sign with you, right? Those sort of things are not acting in good faith, right? If I've done everything, I worked hard, I've gotten you a contract, it's $5 million, I've got all the paperwork ready for you to sign, you can't take off to the Bahamas so you can't sign the contract, you've got to act in good faith and sign the contract and allow me to then get my 20%. That's what the court means by all contract law requires all parties to act in good faith. All right, so statute of frauds. Statute of frauds is an old term in which has been around for a long, long time. It comes because back in the old English days, what you would have happen is everybody would pay for their own witnesses to come in and say, this is what the contract was. And a lot of those contracts had to deal with some pretty extensive things in which there could be some serious consequences to someone to lose on a contract. So a lot of times it had to do with property. And so the court said, look, under these types of situations, if you don't get it in writing, if you don't get the specific terms or the general terms or something that the court can rely on, if the defendant doesn't sign it, then we're not going to hold the parties to an agreement. It made it much easier, again, predictability for the court and ability to make a determination as to any remedies if somebody was to breach that particular contract, i.e. not perform on that contract. All right, so that was how the statute of frauds was developed. It's been around for a long, long time. There are some folks that are not, think we should expand beyond what it is. There are some parts of the statute of frauds to this day, for example, the sale of goods being $500 or more. Well, that provision basically almost in all sales of goods anymore, right? $500 is not a big deal, right? You go down to your Best Buy and you buy a new TV for $800. Well, technically that exchange needs to be in writing according to the statute of frauds. All right, statute of frauds, these are things that have to be in writing. Any transfer of interest in land, right? So any transfer of interest in land. The reason why I use interest means if it's a lease for more than a year, that's an interest in that land. If it has to do with the wells or the water rights or many mining rights, not the land itself, right? But you're just selling the rights to do something on it. That's an interest in that land, right? All of those types of contracts must be in writing, right? Any contract that cannot be performed in a year. The key to this is cannot in any way, shape, or form be performed in a year. If it can be performed in a year, then it is not required to be in writing. Let me give you an example. We agree, my daughter's getting married, and I agree, and the wedding's 15 months out. And I want you to deliver 200 chairs to me for that wedding, right? That contract cannot be performed within a year because the date for that, it would do me no good for you to deliver the chairs to me in 11 months and me have to store them and you not have use to sell them and rent them out to other folks, right? So if that contract cannot be performed in that time period because it has to be 15 months out, right? That's a contract that cannot be performed in a year. If in any way, shape, or form it can be performed in a year, then it is not subject to the statute of frauds. Let me give you another example, an employment type of contract, right? Where you agree that you get all weekends off for the next 3 years. Well, that contract can be formed at any point in time. Whereas if we say, look, I agree that after you've worked for 3 years, you can have weekends off. Well, that you can't fulfill your part of that agreement until those 3 years are done. Therefore, it cannot be performed in a year. All right, so contracts that cannot be performed in a year. All right, any agreement to pay the debt of another. Think about a cosigner, right? If there's a situation where your parents are co-signing on a loan or for a car, for your school or whatever, anybody where in which they may not otherwise be understood to be subject to a contract, right? They're an outside. They really may not be getting a benefit from that particular contract, but they're agreeing if this person doesn't pay, I will pay it. Or they're agreeing to pay it outright, right? In those situations, then that co-signer is going to have signed on that contract. And it has to be in writing. If the contract entered by an executor to an estate, so usually we remember that old case we talked about earlier, the Hammer v. Segway case, right, where the uncle agreed to pay nephew if he refrained from doing things, right? In that situation, if the contract is entered into by the executor, a person that's in control of an estate, then that all has to be in writing. So if that executor goes out and is agreeing to a contract for whatever reasons as part of the estate, it could be maybe it's a living something to do with preparing the house to get the house prepared for sale. That contract needs to be in writing with the executor. All right. In consideration of marriage, right? So prenup agreements, right? Those need to be in writing. And anything that has to do with a marriage and conditions of marriage, those have to be in writing. Sale of goods worth $500. I already talked about that a little bit. That's the one area where a lot of people are like, well, $500 is so low anymore in today's markets that perhaps that's a clause that should be changed. But to this day, it's still $500 or more. All right. Now, the purpose, again, is to provide the court with the best evidence of the parties' intentions in these key areas in which the courts have decided. These are important areas. Marriage, right? Somebody's estate, because they're dead, so they don't have any control over their estate anymore. Agreeing to pay somebody's debt, they're not going to be part of the original contract, so they're not getting anything. So we want to make sure they were clearly involved in that contract, and it was all done in writing. And so those are all important, and obviously any interest in land. Those are all important things, and we know exactly, because it's in writing, what the parties intended when they entered into that contract. All right. Once a contract is fully executed, it makes no difference that it was unwritten. So in other words, if the parties agreed to allow somebody to mine the land for 5 years, but they never put it in writing, the person mined for those 5 years, and both parties person who was mining paid to get it done, and the person who mined had access to that land for 5 years. In the 6th or 7th year, you couldn't come back and sue them, but the understanding of, I don't think we're going to have a contract here because we didn't have it in writing. Since everybody's fully performed on that contract, doesn't matter. All right. So again, we've talked about the purpose to provide the court with the evidence of the parties' intentions. A secondary argument for a court is inequity, right? What I mean by that is, we've talked about these previously, kind of keep going over those again, is if we have some idea of what's going on, right, because there's a contract there, we can easily decide what the remedies are. If it's not in writing, doesn't mean you necessarily lose, but you're going to have a more difficult time. You're going to have to show, again, that there was a promise, there was a reliance, and there was a detrimental reliance on that particular promise, or that clearly the defendant got a benefit as a result of whatever was promised to them, right? That's that quasi-contract equitable relief. So a secondary argument is, if you don't have it in writing, is to say, hey, look, we want you to stay in equity court. We want you to determine what's right in this particular case, even though we don't have a contract. And that's where these different remedies are. For example, promissory estoppel. If you remember right, promissory estoppel is where somebody makes a promise. A promisee, right, the person who the promise was made to, relies on that promise, and then as a result of that reliance, something bad happens to them, right? So those are one of, I should say, inequity type of situations where the court will come in and say, all right, we don't have an actual contract here, but because somebody clearly promised something, somebody clearly relied on that, and to their detriment, we may step in and allow some sort of remedy. Other types of inequity exceptions to the statute of frauds include, look, if there has been a full performance by a seller, for example, of a property or goods, right? We may require the purchaser of that to actually fulfill their end of the contract, whatever it may be. Say, for example, you agree to sell a condominium as you're the seller of the home, and you sign over the deed the court may come back in and say, look, you're going to have to pay the $150,000 that you agreed to pay, even though everything wasn't in writing in this particular case. A lot of times, one of the reasons people put things in writing when it comes to property is they also put into a clause what's called earnest money, so everybody understands that if somebody bails on a particular contract, that earnest money is going to be lost. That means you're promising to give them time to complete or to make a decision on buying the property, but if they choose to back out at that point in time, you're not harmed. Even though you could have found other buyers potentially, you're not going to be harmed because you're going to get to keep whatever that money is. That's called earnest money. All right, so in a full performance by seller, the court may step in and require the buyer to fully perform their end, right? And then, what happened there? There we go. Part performance by a buyer. In the situation where it is clear there was an agreement that wasn't in writing. Let me give you an example. You're agreeing to sell somebody your land. They, as a result of that, they go on the land, they start moving earth to build the foundation, they pour the concrete for the foundation, they start to frame the house, and you come back and you say, never mind, I'm not going to sell. And it wasn't in writing, so we never really had a contract, so I now get the benefit of everything you did. The court probably going to come back in and say, no, 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 no. They have clearly indicated in this particular case here that there's been part performance of them coming onto the land and building and those kind of things, and therefore you're probably going to have to fulfill and sell them the land. All right. Partial payment plus entered or improved is usually what's going to be required for part performance by a buyer, especially when it comes to land, but it can become goods as well, right? All right. Agreements that cannot be performed in a year. This is one that people kind of get, tripped up on sometimes. And again, it cannot be performed. So when you're reading one of the test questions, really ask yourself, could somebody fulfill this contract within a year? If they could, then the statute of frauds doesn't apply. It would not necessarily need to be in writing. And so the fact that it was in writing doesn't mean the court wouldn't step in and do something, right? And then remember always when you're doing those test questions, even when you have a situation where it was supposed to be in writing, think about those inequity situations where the court might do something in equity. You're going to get at least partial credit for putting that kind of stuff and showing that you understand those equitable remedies, if you will. All right, agreements can't be performed. The key is it cannot in no way be performed in a year period of time. If it's possible to perform in a year, it doesn't have to be in writing. If it cannot be done within a year, then it does have to be in writing, right? Let me give you an example. I think I talked a little bit about the getting off a salesperson agreement is you get off all Sundays, right? If it's you, I agree to hire you. Part of the agreement is you get all Sundays off. That can be done within a year, so it doesn't have to be in writing. It'd be better to get it in writing. Don't get me wrong. It'd be better to get it in writing because if you wanted to sue them and say, hey, he promised me these, but you don't have that contract to show that it was promised, it might be a little more difficult, right? But that's something that did not need to be in writing. They couldn't come back and say, well, it was never in writing, therefore we didn't have a contract, etc. All right. It has to be possible for perform in a year. All right. Promise to pay debt of another. We've talked about that. The collateral promise, right? Again, we talked about the reasons why if this other person who's not getting the benefit of whatever the original contract is, whether it's the car, whether it's the rental agreement on a lease for over a year, whether it's just a rental agreement period that this person's agreeing to pay, right? Even though it's not, it could be done. It's a month to month, so it's not a contract that would otherwise need to be in writing. But because somebody else is agreeing to pay that debt, and you want them to be pay that debt, you're the person that owns the property renting it out, right? You need to have this person on this, well, then that needs to be in writing. There is this rule, I don't want you guys to worry about it too much, but it's called the leading object rule. The leading object of the promisor is some benefit to the promisor. Let me give you an example. So I think your book has a pretty good job of talking about the old pig farm is usually the example it's used in your book, if I remember right. If not, then I'll kind of give it. So you have a pig farmer who needs to obviously have food for the pigs to fatten the pigs, right? In order to sell the pigs at their greatest market value, you got to fatten them up. So you're the feed, because you owe money to the feed company, they stop you from buying any more feed. So you go to the bank, who owns the land that you're paying a mortgage on. So there's a benefit for you to use that land and continue to pay them back on that loan. They're agreed to give you some more money to pay that feed company, right? In that type of a situation, that's called the lead object rule. There's a benefit to them in selling or loaning you that money. That contract would not necessarily have to be in writing. That's essentially called the leading object rule. Again, don't worry about it. It's wonky. If you go into law school, you have to learn about it, but you'll have at least a little understanding when you get there. All right, promise made by executors to the estate goes without saying. If you are in charge of a dead person's estate or in a situation where a person's incapacitated, right, everything you do obviously needs to be in writing, because again, think about it as similar to the promise to pay the debt of another, right? That person is incapacitated or dead. They are no longer involved, and you can't tell who that they're agreeing to these things. So all those things need to be in writing. Excuse me. All right, promise made in consideration of marriage. We talked about that. Prenups, those kind of things, all need to be done in writing. In the old days, it was dowries, where any of the dowries sort of needed to be in writing, because there would be arguments over how many goats you were entitled to, or how many pieces of silver, whatever it was. Those were the types. But now, to this day, it's usually prenuptial agreements are the big thing. Those need to be in writing. All right. All right, here's what and when it comes to statute frauds, we want to talk about what does the writing, right? Okay, it needs to be in writing, but what needs to be in that writing is now kind of what we're turning to. The biggest thing that needs to be in there is the signature of the defendant, right? If you're going to sue somebody and you're suing them based on a contract, and it's in that area in which it needs to be in writing, well, that other person that you're suing, saying they didn't fulfill their end of the agreement, their signature needs to be on that document. That's what I mean by the signature of the defendant. I put in their e-signatures are valid. They're becoming even more. For example, our courts, everything, almost everything I should say, I sign these days is done electronically. Courts aren't too concerned over if it's electronic or not electronic, if it's an X or a symbol like Prince used, whatever. Just something that indicates you as a defendant agreed to this particular contract is what we mean by signatures. All right, must state with certainty the name of each of the parties. We need to know who all is involved in this particular contract. Must state the subject matter of the agreement, right? It can't just be me and Johnny agree and my signature's on there, right? I got to know what you're agreeing to. Got to know kind of specifically as to how, if it's a goods type of situation, how many goods, what's the quantity of the goods, what's the selling, the price of those goods, those kind of things, right? There has to be some idea to alert the court what the subject matter of the agreement was. The essential terms of the agreement need to be in the writing itself. All right. The parole evidence rule. What I want to make sure you guys understand by this, and there's absolutely at least one, if not two questions on the test dealing with the parole evidence rule. The parole evidence rule means the court will not consider that information in regards to a contract, especially a written contract, in which essentially all the terms of the agreement everybody signed on to. Parole evidence means that information that was obtained before the contract was signed. And the reason the court doesn't consider that information is because the court is saying, look, we don't care what the negotiations were. We don't care how you got to where you got. We just care what's in the four corners of that contract. That's it. Once we have the four corners of that contract and both parties have signed on to that contract, or in a situation in which you're a defendant, you've signed on to that contract, we don't care And we're not going to listen to or use any of that information that occurred before. That's what parole evidence rule is. There are exceptions, and of course we're going to talk about those exceptions. But parole evidence rule starts with the presumption the court will not consider any information before the contract was signed, after the contract was signed. We're only going to look at the four corners of the document. Okay? That's what kind of parole evidence rule is all about. So when two parties make an integrated contract, and I'll have those, it'll be in the slide itself, but integrated contract is an agreement. This is it. We all agree that these are the essential terms of this particular contract, right? Then neither one may use that parole evidence to contradict, vary, or add to anything within the four corners of that contract, right? Now, an integrated contract is a writing that the parties intend as the final, complete expression of their agreement. That's why when we say they've signed that contract, all we really care about is we expect you all to put everything that you think is important for the court to consider inside of those four corners of that document, and that makes it an integrated contract. This is what our agreement was. It's within those four corners. That's an integrated contract. Once that occurs, we don't care about the negotiations. We don't care about what somebody promised. If it was important part of the agreement, then you should have put it in the four corners. All right. An integration clause is found in contracts, and in most contracts, and it usually says, look, this contract, these four corners, everything contained within the four corners on this piece of paper, or papers, of course, is the full and final expression of what the parties intended in this particular contract, i.e. alerting everybody's read it, everybody agrees to it, and everybody's signing off on these things that are these terms. Yep. Now, if the contract is not complete or has ambiguous terms, the court may allow allow parole evidence only for those incomplete or ambiguous terms. Remember, I told you there are always some caveats to these things, right? If it is just we're not sure about that, then usually what the court will do is say, all right, what do you guys got specifically to those terms, and we may use that information. Don't bet on it, though. Court will allow parole evidence in regards of fraud, misrepresentation, or duress. Let me give you sort of an example. All right, so Slick Willie is a real estate agent, or maybe he owns the property. Let's say he owns the property, and he's so Hillary comes over to Slick Willie's place, takes a look at it, realizes there's water around, and wants to know, has there ever been a flood or ever been situations in which water has come up and to potentially damage any part of the house. And Slick Willie says, absolutely not, never happened. If that had happened, I would absolutely have told you. So relying on that, Hillary ends up purchasing the home. As it turns out, Slick Willie wasn't telling the truth, that in fact that had flooded, and it flooded several times, and there was actual damage that had been done as a result of those flooding. If Hillary wanted to come back and sue as a breach of contract, saying, look, I never would have entered into this contract. I don't have any problem with four corners. I'm just saying I never would have entered into it, but for that fraud or misrepresentation by Slick Willie. Then if there is any evidence of what that was and that question and why that question was asked, then that evidence gets to come in, right? So courts allow parole evidence in regards to fraud, misrepresentation, or duress, because that's the whole part of integrated clause. Is clearly there was a meeting of the minds, everybody agrees what's in the four corners of that document. Well, if people entered into that four corners of that, entered into that agreement, not fully appreciated because somebody fraud or misrepresented or did something, held a gun to somebody's head, well, then we're going to let you bring in the fact that somebody held a gun to your head, and that's why I entered in the contract, because it was not fully agreement at that point in time. All right, hope that makes sense. All right, it's not working here. Let's see if we can get this thing to move. All right, you guys get to be the judges. All right, so Jill, who is a very good lawyer, employs Jack, an up-and-coming attorney. to assist her in suing a major pharmaceutical company in a class action lawsuit. Jack is spending a lot of time away from family, so Jill says, don't worry, I will make sure to take good care of you if we win. She does win. She wins a $100 million lawsuit against the pharmaceutical company, and as typical, if you go to trial, she gets about 40% of the take, which means she gets $40 million. Her and Jack sit down to discuss his bonus. Unbeknownst to Jill, Jack records the conversation. In Oregon, that's actually not legal, but regardless, that's this parole evidence, right? That would be information that the court could use potentially regarding their agreement. Jill agrees to pay Jack $1 million. She's going to give him $100,000 up front to begin those installments, and then $25,000 per month after that until she reaches that $1 million. Jack is ecstatic, of course, uses $100,000 for a down payment on the home, with the understanding he'll get that $25,000, and that's what it's going to use to pay back the mortgage on that home. After paying the $100,000 and making 15 payments, Jill, loses some other cases and loses money on bad investments and decides that, she's going to stop paying Jack. Jack sues and brings this case to the court, including his recording of exactly what their agreement was and that they had an agreement. All right, is Jack going to win the lawsuit? All right, so here's the first thing that you got to ask yourself. We talked about that. Does this agreement that they have need to be in writing, right? Because it's not. I never put anywhere in here that it was actually in writing. Can Jill fully perform this contract within a year period of time? Answer, no, right? If you do the math regarding the $25,000 in order to get up to $1 million, it's going to take more than a year. So it needed to be in writing. There's a little caveat to all this. If you kind of go back to the materials we talked about before, there's other thing that's lacking as well. That the court, even if they had entered into a contract and had been done in writing, might have said you still didn't have an agreement here because there's some consideration that's potentially lacking in this particular case. But I think there's an argument to be made that the extra dollars that she was going to pay was going to be for work that he performed when she sat down and said, don't worry, I will take care of you. He then continued to perform work, and so I think you could argue that consideration was there. But don't forget your other contract parts, right? That there was an offer, acceptance, and consideration, etc. All right, but it clearly needed to be done in writing. Well, Jack's like, no big deal. I can show you, even though we don't have it in writing, I can show you what our agreement was, right? And the court's going to come back and say, yeah, but it still needed to be done in writing. It doesn't make a difference what your agreement was in this particular case here. And we're, of course, probably not going to consider that parole evidence, that tape recording of what the actual agreement was. So I think in the end, he's probably going to lose out. Now, the court may say, look, what would have been a reasonable compensation for him, and determine if there needs to be some more additional money because of the time he spent and what he could have done elsewhere if he had gone somewhere else. There are other equitable remedies the court may use that parole, that tape recording, to make the determination regarding what equitable remedies it might want to impose. But certainly, it couldn't be, look, I bought my house, I'm going to lose my house because she doesn't pay me. Well, she never knew he was going to use the money for the house, never used that he was banking on getting that money to continue to pay on the house. So court's really probably not going to bail him out for that either as well. He didn't have to do that. He could have waited until the money was actually in hand before he made any of those decisions and chose to do things ahead of time. So more than likely, the court's going to determine that because of the could not be performed in a year, need to be done in writing, and court probably wouldn't allow that tape to come in. All right. What rule prevents using that tape recorder? That's that parole evidence rule, right? All right. Other than Jack, we talked about that. The equitable remedies. I apologize. I didn't realize on that particular slide it was still underneath what the actual video is, where the video is. Basically is what other arguments might use, and we've talked about the detrimental reliance, sort of a promissory estoppel, maybe a quasi-contract with some idea. We'll talk about some sort of interest expectational interest sort of to remedy. All right. Let's kind of move on now, continue about performance and discharge. Again, just a reminder that most contracts are discharge, i.e. no longer in play. Everybody's done what they need to do as a result of everybody fully performing their part of the agreement, right? Almost all contracts out there, 90+% of all contracts, end as a result of full performance. They are discharged, means nobody has any longer obligations to the other party. That contract is done. You couldn't come back and sue again because everybody has fulfilled all their parts of the agreement. All right. Most contracts, again, discharged by full performance. So let's talk about what discharge means. A discharge means a party is discharged when a party no longer has a duty under a contract. And discharging a party can be done in multiple different ways. It could be done because they fully performed. It could also be done because somebody has breached on that contract. It can also be fully discharged because everybody agrees we no longer want to go forward with this particular contract, right? That's called rescinding of that contract. Both parties have to agree on that. It can't be unilateral rescission. It has to be one party agreeing, or both parties, excuse me, agreeing to no longer be held obligated under that contract. Usually, if it needs to be in writing, that rescission is going to need to be in writing as well. All right. Conditions or conditional contracts. So we want to talk about an event that must occur before a party becomes obligated under a contract. Again, because until that occurs, right, then you don't have an obligation and you can't discharge it until that subsequent event or an event happens in order for you then everybody to fully discharge their parts of the agreement. So there are certain types of contracts in which some conditions have to occur before obligations occur and people have to perform under a contract, right? Let me give you some examples real quick. It's to sell a property, and we all agree I want to build a movie theater on that piece of property, but the zoning currently is not allowing movie theaters. In order for me to purchase this big piece of property, we both agree that in order to go forward, me purchasing this property from you, I have to be able to get it rezoned. So that condition of me getting it rezoned must occur before I now have to pay you for that property, right? That's it. There are other types of implied conditions. Landlord, you guys all enter into rental agreements. If you're in a rental agreement, part of your rental agreement says that the landlord agrees to keep the property, livable. So if you got a leaky faucet or something's not working the way it's supposed to be, right? They're supposed to fix those things. But those obligations to fix those things don't occur until you tell them, right, what those things that are wrong are. But once you tell them, they have an obligation and they have to fulfill that obligation, right? Those are express and implied. The implied one being, obviously, if you don't tell them what's wrong, they can't fix it, right? So but that's still an implied obligation on you. Theirs is expressed, right? Theirs is they fix it. Implied on you is you got to let them know what that problem is. Okay. Hopefully that makes sense. All right. Express conditions, clear from words in the contract, what we're supposed to do. Again, on that landlord agreement, as a landlord, I'm agreeing to maintain and make the place livable. The implied condition is you got to let me know when something is wrong. All right. All right, so some of the types of conditions in legalese, we use condition preceding, condition subsequent, so I want to talk a little bit about those. Let's talk about condition preceding first. Right, it's an event must occur before a duty arises. I just sort of talked with you all about the landlord situation with you all. In your rental agreements, there is a agreement that if something is wrong with the property, a leaky faucet or whatever, they're agreeing to come in and fix it. But there has to have a situation where you need to tell them before that actual obligation occurs. In other words, you could have a leaky faucet for a year. If you don't tell them, They never had an obligation. You couldn't sue them for a breach of contract. It is implied that you're going to let them know before that condition becomes something that they have to fulfill, right? So that's that condition precedent. You're going to let them know, right? That's a condition precedent. Something's got to occur before any duty arises. Another good example is sports contracts, where you have those incentives where I agreed to pay you an extra $50,000 if you score 10 touchdowns this year. Well, if you don't score 10 touchdowns, I never have an obligation to pay you that $50,000, right? That condition has to occur before I'm obligated to do so, right? There are conditions subsequent. An event must occur after a duty arises. Good example of this is car insurance, or if you own a home, homeowner's insurance. Right? Usually there is an agreement, of course, that if something goes wrong, the insurance company is going to pay. But there's usually, in order for that to occur, you got to let them know again. But that's a condition subsequent. So their obligation to fix whatever went wrong happens as soon as it got broke, right? Or fire. Say it's a home. Their house gets burned down, right? Usually under the contract, there is a provision that says you need to notify them within X amount of days. Let's say, for example, 60 days of the house burning down, about the house burning down. And then they have an obligation to go fix your house. If you don't let them know about it within that 60 days, right, then they don't have an obligation. They may not have an obligation at all because you didn't let them know within the time period expressed in the contract. But that's a condition subsequent. So the burning of the house happens, right? That's the condition that happens. Now, afterwards, I have to let them know that the house burned down within X amount of time. If I don't, then they're not going to have to fix the house, right? That happens. You'd be surprised times in which people don't notify their insurance companies within the appropriate period of time of what occurred, and therefore, the insurance company goes contractually, that obligation, performance that they would need to do otherwise goes away. That's a condition subsequent, right? It's usually a defendant that has to prove that that event occurred, relieving them of the duty to perform. So, for example, in my insurance company, it's usually the insurance company that would have to prove that they didn't notify them within that 60 days. Therefore, there was no obligation. That contract was part of the that clause was part of the contract, and they didn't perform, right? There are concurrent conditions. Both parties are required to perform at exactly the same time, right? I agree to turn over the deed to the property at the same time, sign over the deed to the property at the same time you're agreeing to pay me $200,000, right? So I don't have to sign it over and hand it to you until I got $2,000. At the same time, you don't have to hand over $2,000 to me until I've got that deed ready to give to you, right? That's kind of that condition concurrent situation. All right. All right, performance. All conditions are completed. We talked about 90+% of all contracts are completed as a result of full performance, right? That's what performance is, all conditions completed. There are different types of performances, though. We need to talk about that, right? Because in some situations, there is different types of what is performance under a particular contract. And sometimes full performance isn't necessarily required, just substantial performance is. And let's talk about that at this point in time, right? Again, how most contracts are discharged as a result of performance, so we're going to get into a little more details about what performance is. So, strict performance clause in a contract. I mean, it requires one of the parties to perform the conditions of the contract exactly or precisely as bargained for in a particular contract, right? A good example of these types of contracts are where somebody's going to machine something or some specifications of this part, and they have to be exactly those specs in order for it to work in whatever you're going to use it for. So, for example, a widget has to have a specific specs in order to go fit into my gadget that I'm going to be putting together. The widget goes into my gadget. If it doesn't meet those specifications, I can't use it, right? So, a strict performance contract requires one of the parties to perform the conditions of the contract exactly and precisely as we bargained for. But it's going to be in the contract. It's going to be, this needs to be exactly this done this way. If not, then you haven't performed. Even though you've given me 100 of them, and that's what our agreement was, 100 widgets, because they don't meet the standards that we talked about in our contract, you have not performed in that particular. Right? There's a strict performance clause in that. It has to be reasonable requirements and for a purpose, right? If in my widget scenario that's going to be going into my gadget, if there was really no reason it could be off and it still performs absolutely right, then it's probably not a clause that the court's not going to take a good look at, or say, nah, these fit within that performance situations. But if it's clear, parties agreed, doesn't fit, and they were reasonable, then the court's going to adhere to that contract. Substantial performance, where one party fulfills enough of the contract to obligate the other person to fulfill their end. Really, the best example of this is in houses. Most houses have a clause in the statutes, clearly, even if they don't have a clause, regarding that if a house is, able to be lived in reasonably, situation, it's safe, but maybe the garage isn't completed, whatever it may be, but everything is friendly, then that will be substantial. Now, it doesn't mean the court's not going to come in and say, yeah, you agreed to pay $200,000 for this house to be in this particular condition, and it's not in that condition, and therefore you may not only have to pay $180,000, or we may require the construction company to pay for coming in and finishing that garage, whatever it may be. But if it's substantial performance, then you're still going to have to pay for the work that they did do. All right. Party who does not fulfill the entire contract must prove they substantially complied. Right. You may be arguing as the homeowner, look, they didn't comply. This is what our agreement was, and they need to come in. Yeah, but we got the house into such a condition that this person could actually use the house as intended. Evidence that may demonstrate the level of performance. How much benefit has the promisee received? Construction contracts can the owner use for the intended purpose, i.e. can they go live in it? And can the promisee be compensated for any defects short of voiding out the entire contract, right? Is there something we can do, reduce the amount or whatever, something we can do to essentially fulfill the contract, making both parties as whole as possible, then that could be a substantial performance situation. All right. Did the promisor act in good faith? If it is clear they went agreement and they just, I got to move on to other houses, don't care about the garage not being done, then the court may come back and say, yeah, you haven't fully performed at this point in time. So there's some breach and some remedy as a result of that breach. Yep. All right. Performance again. There are personal satisfaction contracts in which the court will sometimes utilize and or agree at a provision regarding a substantial contract, right? Usually the court's not going to allow personal satisfaction contracts. It's got to be there's some really good reason for a personal satisfaction clause in a particular contract before the court will adhere to that particular contract. Otherwise, the court's going to really kind of what's reasonable between these parties in these kind of situations, right? But a personal satisfaction contract permits the promisee to make a subjective evaluation of the promisor's performance, right? A good example might be I sell furniture. It's high-end furniture. It's very wonky sort of foo-foo type of a furniture, high craftsmanship, whatever. And so I go to an ad company and I want that to be reflected in the ad that they come up. I don't want some really bad ad. So I say I need to be satisfied with this before I'll pay you for that, right? That might be a situation where personal satisfaction contract exists. Maybe an art situation where, look, I want my walls, it's a museum, an art gallery, and I want the walls painted a certain way, and I need to be satisfied that they're going to be able to do what I want to do as far as this museum goes, or this art gallery goes, right? there is a purpose behind that. The court's going to allow that. Now, say for example, it's a big museum or a big gallery, and now you want to like, look, I need some printers for this, or I need some fire extinguishers or whatever, and I need to be personally satisfied that they're going to work right. The court's probably going to come back in that sentence and say, yeah, you don't have any special qualifications in that particular area to be a person who can really subjectively make that type of determination, right? So in that situation, the court's probably not going to allow a personal satisfaction contract to exist. All right, that's what a personal satisfaction contract is. There's some purpose behind that. Okay. Subjective allowed if the contract clear on who and necessary for promise E to get the fulfillment out of the contract. Right? An objective standard is a reasonable standard within the industry or market. That's really on that printer type of situation. That's really what the court's going to use as the objective standard. All right. There are time is of the essence clauses in which a clause of the contract provision says, look, there is something making you fulfill your contract within this time important, and if you don't, you're in breach, and I can do what I need to go do as a result of you being in breach. A good example of that might be perishable goods like an apple or some sort of fruit or something of that nature, right? It basically says, look, if you don't, deliver these apples within 10 days, then I'm going to move on and get them from somebody else, right? There might be a time of essence clause for that. And if they don't fulfill it, right, then they could be held in breach. So merely including date does not make it of the essence, though, right? There has to be truly something behind making it of the essence. Perhaps I've got a contract in which I need to give 1,000 of my gadgets to somebody, and I need, your widgets within 10 days for me to fulfill my contract. And we agree you're gonna get those widgets to me within 10 days so I can put them in and deliver on time to those gadgets to somebody else I've contracted with, right? So now time is clearly of the essence. If you don't get them to me in appropriate time, I can sue you for breach. I can go see if I can find them somewhere else, whatever it may be in that situation. So it has to be, reasonable. It has to be clear that it was needed. In good faith, remember, it's always required. You don't get to do any shenanigans. That's basically what I'm talking about. Don't try and rest your defense of a good contract on I acted in good faith, so please don't hold me in breach kind of situation. That's not going to be a good situation. And contrary to that is, don't try to say, while I was out and about, right? I remember that athlete who with the $5 million contract. Well, I just want to take a vacation at that. Well, again, but I was acting in good faith. Courts generally aren't going to let it. But remember, good faith is always required. Courts don't require duty on one party to act as a brother's keeper. What I mean by that is, if you enter an agreement, we don't care if this person withheld information from you that wasn't necessary to the agreement in the contract, right? It wasn't like a misrepresentation or fraud. Just because they didn't tell you everything, that's negotiation. That's how the world works out there. They don't have to tell you everything in order for you to make a good deal on. Just because they didn't tell you everything doesn't mean the court's going to let you out of that particular contract, right? That's not what we mean by good faith. But there's clearly something that's material, important, that's clear misrepresentation, clear fraud, then that's where the situation where good faith is going to help you in that particular contract. All right. Discharge of contracts, right? We've talked about most contracts being discharged by performance. We've talked about what performance is. Now, there are other ways in which contracts can be discharged. So some contracts obligations are discharged when one party doesn't perform in a contract, i.e. they breach, right? If I'm agreeing to pay you $10,000 for 500 widgets and you don't bring the 500 widgets, I obviously don't have to pay you $10,000, right? Your breach means my obligation to pay the $10,000 goes away. Okay, that's kind of what we're talking about here and how that works. My obligation to pay the $10,000 is discharged. You couldn't sue me because you breached the contract, right? So let's talk about what that means. A breach is when one party breaches a contract, the other party is now discharged from their obligations, what I just sort of told you, right? Again, when one party breaches means they didn't perform as they were supposed to in a contract. That's what a breach is. It has to be a material breach, right? Excuse me, a material breach is one that substantially harms the innocent party in which it would be hard to compensate them without letting them out of the contract, right? So, for example, in my widget scenario, if you provided 435 of the 500 widgets you were supposed to give to me, right? But we agreed right? 500 is what you, or 5,000 is what you were supposed to get, right? I think I'm mixing them up. 500 is what you were supposed to get, but you're 65 short. Court's not gonna say, well, that breach is enough to where you don't have to pay them any of that $10,000. Court's gonna say, no, look, they've materially complied, they've given you that much. Yes, they're in breach. Yes, we'll figure out as a result of those not having those 65 other widgets what that means, but you're going to have to pay them for that 435 widgets that they did give to you, right? So a material breach is something that was clear, that was needed. Otherwise, you can still perform under that contract. Anticipatory breach is a clear act by one party making it clear that they will not honor the contract. Good examples of this are working contracts, right? Where, say, you just got done with school here at Pacific University, you worked really hard, you've gone to some of the functions in which other employers are there and kind of job fair type of situations. You do interviews, and they're like, all right, at the end of the summer, we're going to hire you, and you're like, great. And so and then there's an agreement made. You guys each signs a dotted line about what that is, and then you read in the paper that they went out of business. You don't have to sit there and wait till the end of the summer to say, aha, you're in breach. Therefore, I'm now going to go look for work elsewhere. Right? You can go ahead and look elsewhere because you need a job, and the court's not going to require you to wait. Right? That's anticipatory. Somebody does something. They call you up maybe and say, look, I'm never going to make these 500 widgets that I have for you. Just not going to do it. Sorry, I'm not going to deliver them on time. I know times of this. I'm not right. The party acts that way. That's all right. Now I need to go figure out what I need to do. In fact, some instances we'll talk about mitigating your damages. You have an obligation to do things to mitigate those damages, how bad they would otherwise be. But an anticipatory breach is where a party does something that makes it clear that they're not going to fulfill their promise in a contract. Okay, so we're talking about ways in which people can be discharged from their obligations in a contract. And so there are some other ways, right? We've talked about full performance. We've talked about breach. There's also other ways in which a person maybe can't perform, and the court's going to allow them out of those obligations. For example, impossibility. True impossibility for the court is, all right, when everybody reached an agreement, nobody would have anticipated these sort of things happening. If you remember, right, 3, 4, 5 years ago, there were some really major fires in California, and they occurred in sort of the Napa Valley, which where a lot of wine is produced. And sometimes some of those vineyards, not only was the vineyards where all the grapes and the grapevines were wiped out, but the actual facility in which they were holding barrels of wine to be fermented to then be sold were also wiped out, right? And so, for example, you make a contract with somebody to sell 100 bottles to them, right? With the understanding you're not going to sell it to them for 2-3 years potentially, right? And so when those vineyards and or whatever quantities they had on hand were wiped out, the court discharged those vineyards from those obligations because nobody anticipated what had occurred, and it was a true impossibility for them to actually be able to perform on that contract. So they were discharged from their obligations, right? Usually has to be destruction of the subject matter. It may be the death of a promisor in a personal service contract, for example. Perhaps it was a lawyer, an artist, or something of that nature. Obviously, you can't sue somebody because they didn't finish the artwork when they died, right? Those kind of things. So on those situations, there's no way they could perform anymore because they're dead, right? If it was illegally created after the contract was formed, we've used this example before, where military grade type parts were being sold to Iran in the late 70s. Contract existed, and then when there was a situation occur between the Iran and the U.S. when they took some of our folks as hostages, right? We made it illegal to sell parts to them. At that point in time, it became a true impossibility for people to perform. Otherwise, they would be, imprisoned or fined or whatever. And so, something becomes illegal afterwards makes it a true impossibility. All right, there's commercial impracticability and frustration of purpose. In these situations, it's rare. We're still maybe going to hold somebody in breach of a contract, but it has to be something to some degree that's really, really makes things, no sense in doing that. Maybe a lot of ships got wiped out, in which that's how you transport your goods to somebody. As a result of those ships being wiped out, now it's costing you 5, 6, 10 times more to ship the goods than otherwise. So the purpose, you're losing money. In order to ship those products, it's going to cost you $100. You're only making $80, so you're losing $20 for each one of those items, right? So now it makes it commercially impractical. We may discharge you from those obligations. There's probably still going to be some remedy that we're going to give to whoever you made the contractual agreement with. We'll talk about what those might be, what those remedies are. But to some degree, you're going to get out of your obligations by arguing commercial impracticability or frustration of purpose at that point in time, right? Because the purpose of business is to make money. You no longer can make money. It was unforeseeable. Nobody saw the hurricane coming and all those ships being wiped out. Right? Neither party could have anticipated the future event. It was truly unexpected. It's going to be a major financial burden to require one of the parties to fulfill the promise in that event. As a result of that, right? Frustration is, again, they're basically the same, right? Truly unexpected event. Contract no longer has any value for one of the parties, right? So a lot of contracts have in them what's called a force majeure clause. It means the terms of the contract that allows cancellation in the event of some extraordinarily or unexpected, like an act of God is one of the terms that are used in there, right? And if there's a contract that has a force majeure clause that says in the event of some of these things happening, this act of God, then everybody understands that the obligations are discharged at that point in time, right? That's called a force majeure clause. Seller goods can delay or cancel delivery of goods in the event of active God, fire, labor disputes, accidents, or transportation difficulties. That's an example of a force majeure clause. All right. So what happens when someone doesn't perform, right? We've talked about other ways in which now discharged. Now we need to talk about, well, if somebody does breach their contract, what are the remedies in that situation, right? So what does the court do when one party doesn't do what they promised to do in a contract, i.e. they're in breach? How does the court remedy that situation? That's what remedies are. Remedy is usually not designed to punish the non-performer. We want people to engage in contracts. We want people to perform businesses. We don't want to punish anybody or make people worried about being punished because they don't perform in a contract. So we're not punishing. That's not what the courts are trying to do. We're trying to make parties either whole where they would have been, the position they would have been if the contract was fully performed, or if you can't determine what that is, if they've spent some money on something, get them back in the position they were before the contract was done in the first place, right? That's kind of what remedies is all about. Let's talk about some of those. So again, a breach occurs when a person fails to perform a duty without a valid excuse, right? We've already talked about that there may be times in which impracticability or true impossibility or whatever created a situation where you cannot perform. So in these situations is where there's no real good reason why they didn't fulfill their obligations, right? Remedy is about a court's compensation to that injured party. So let's talk about different types of remedy. And remedies in the legal sense are done by what was your interest? What can the court determine was your interest? And if we can't determine what your interest is, usually you'll see these things kind of go down to the very bottom where it gets into that equitable interest type of a situation. Right? So expectation interest is, we're going to, what did you expect to have occurred if everybody had fulfilled all their obligations, right? So we're going to put the party in a position they would have been had both sides fully performed. A lot of times in an expectation contract, it would be sort of, if I needed a part, let's say we're going back to my widgets and gadgets type situation, right? I'm building gadgets, right? But I need your widget. So I have contracted with you for you to give me 500 widgets to put into my 500 gadgets. I have a contract with somebody else to sell them all 500 gadgets, right? And we know exactly what I would have made had I sold and had 500 gadgets for them. You only produce 400 widgets, so I can only produce 400 gadgets as a result of that, right? What would my interest be, my expectation interest? Well, I would have sold 100 more of those and would have made X profit on those, each of those that's being sold. So your remedy would be typically you, who sold me the widgets, would have to pay me my lost profits, right? That's what expectation interest. As if we'd fully performed, where would I have been? Well, I would have been having X amount of profit from that, so you're gonna have to pay me for that, right? A reliance interest is we can't really prove what the losses are to me. Maybe I'm producing 500 gadgets, but I don't have a contract with somebody else, and I may not sell, right? A lot of times things get damaged in shipping, and so there's an idea of an expectation of some things not being fully performed. It may go out of style, whatever. I don't know what I'm actually going to be able, whether I'll be able to sell those things. So it's hard to determine what my lost profits would have been. But we can prove somehow what my actual losses, or can't prove my actual loss, but can show that I spent money relying on your promise to produce and give me 500, right? I had built my shop. I had done whatever I needed to do. I had advertised and right? We can tell a result of me relying on it, I'm out X amount of money, right? Maybe it be I hire an employee and I agree to move you from Texas to Oregon. I agree to pay first year of your rent when you're here, with the understanding you're going to work with me for at least 3 years, right? Well, my reliance interest is I trained you, I spent money to train you, I moved you, I spent money to move you, and I paid for your housing for that period of time, right? That could be if you breached that contract and decided to go work somewhere else. And there could be reasons for you to go work somebody else, right? Somebody's going to pay you more than what I was going to pay you. But you're going to have to pay me back for my losses in those. That's a reliance interest scenario, right? Restitution interest. You can't show, again, an expectation interest. You can't show a reliance interest, but you can show that a other party benefited as a result of whatever the contractual agreement was. Again, a good example of this is a situation in which say I was going to sell you my land in Eastern Oregon, and you're going to grow wheat on that land in Eastern Oregon. You decide, oh, wait a second, the government's going to pay me $10,000 to not grow anything on that property. And then after 2 years and you've gotten $20,000, you decide you don't want the land at all anyways because you now don't want to farm it, and you back out of the contract and you really haven't paid me anything on that contract. But you gained $20,000 because the government paid you $20,000 not to grow anything. The court's going to come in and say, you know, that $20,000 is going to go to the actual owner of that property because you basically used that land for nothing, and yet you got a benefit from doing nothing and you didn't fulfill your obligation. So you're going to have to hand off that $20,000 to me. And then equitable interest is sometimes where even if you have expectation interest, you know what it is, you have reliance interest, you have restitution interest, there's just some other costs that are involved out there, which are called equitable interest situations, where money's just not enough to fulfill everything. It could be a specific object. We'll talk a little more about this, where the court's going to say, no, look, they can't go get it elsewhere. Maybe it's artwork, maybe it's memorabilia, maybe it's a special car, a special piece of property. Most property is considered unique. And so we're going to require you to actually hand over whatever those things are to this person who you agreed to sell it to. That's specific performance. So the court's requiring you to actually specifically perform as agreed to. And then the court may use injunctions. Now that land situation, right? The court may say you can no longer accept $10,000 on that property and whatever. That's what's basically an injunction. Telling a party they have to do something or they can't do something is an injunction. Preliminary injunctions, if you remember right, are just temporary, and then full injunctions can be you can never do this or you always have to do X if you're under this contract, right? We'll talk a little bit about what those are as well. Okay. All right. Remember, remedy is to compensate for the injured party, generally not to punish anybody. I have to make sure that's clear. Oops, kind of skipped down. All right, injunctions. Court orders that a party to do or not do something, refrain from doing something or do something, right? That's an injunction. We talked about that. Again, we talked about what preliminary injunctions are, where it's a temporary order to do or not do something. And then there are permanent injunctions, which is where, for this particular contract, the party can or is required to do something. And specific performance forces both parties to complete their deal. Again, it's usually a situation where it's a unique item or a unique type of contract, right? The liquidated damage clause is where it would be so difficult to determine what the actual losses would be if somebody doesn't perform that in advance of any breach, we're going to agree that if somebody does breach, this is what the compensation will be. Let me give you an example. We've talked about my daughter's getting married. I need 200 chairs for that, and we're contractually agreeing to do it 15 months out because that's when the date of the wedding is. And look, if you don't give me 200 chairs, Lord knows people are standing up. I don't know what that, but it's certainly not what my daughter would want at her particular wedding. It would be awkward. People would be complaining, right? But I don't know what the actual, loss would be to the enjoyment of a wedding, right? And meanwhile, you're agreeing to and you're setting aside 200 chairs that you could have rented to somebody else if I don't fulfill it. So we put in the clause, say I had to put $500 up front for those chairs, and I'm agreeing that if I cancel, right, something happens, the daughter decides not to get married or whatever, I'm agreeing that you get to keep $200 of that, and then you're agreeing to pay me $200 if you don't provide the chairs and when required to provide those chairs, right? That would be a liquidated damage clause. Everybody's agreeing that if somebody breaches, here's what the other party is going to get as a result of that particular breach. Yep. All right, let's talk about the Hawkins versus McGee, sometimes called the case of the hairy hand. This is a case that is still taught, and it helps to sort of explain kind of how the courts go through these processes of deciding what type of damages, what was your interest in this particular contract to determine what type of damages we should get a remedy, right, when somebody breaches a particular contract, right? The Hawkins v. McGee case is a case in which this young person was working on a toaster. The toaster was old type of electronic cord. It was frayed. It was next to a metal pipe. It's a weird kind of scenario, but whatever happened as a result of pushing down the toaster, Hawkins got severely burned on his hand. Very, very badly. He was very embarrassed about the burn on this. This new doctor comes along, McGee, and was really kind of doing some really early entry skin grafts types of situations, and said, look, if you agree to allow me to do this surgery, I will make your hand 100% as to what it was before, right? He does the surgery. He uses a piece of his chest to do the graft work, to put on his hand. The problem was, what McGee didn't know, which they know now, is, well, that particular Hawkins had a very hairy chest, and they thought the hair would die, but it turns out that hair will grow just as well on the hand as it did otherwise. And so Hawkins ended up with a still somewhat deformed hand that was extraordinarily hairy, making it actually worse than it was before. So Hawkins sued McGee. Originally, the court said, oh, okay, all right, this is easy. You're just going to have to pay him, for the surgery and damages, and we're going to give you some pain and suffering type of damages. And court came back and said, the higher courts, I should came back and said, no. You guys all missed the point here. What was actually promised was a hand to be 100%, and it wasn't. And that was the expectation. Here's what this person would have received if it was 100%. He did not, and damages need to be based on that agreement to get the hand back to normal 100%. He didn't do so. Now I'll go assess damages. They ended up settling out of court, so there was never a final decision on that particular case. But that was kind of how the court went through and decided particular damages. Expectation interest is the direct damages that flow directly from the contract. Promise in the McGee-Hawkins case was 100% hand. So what was the difference between 100% hand and the hand that he got as a result of the surgery? And that's what the jurors ended up with, what we're going to have to decide. Again, they settled out of court. So, all right. Other types of damages are consequential damages or special damages, damages resulting from unique circumstances of a particular injured party. I'll give you an example. Say you call up an Uber driver, and you say, look, I've got a airplane ticket. I have to be at the airport to get on the plane in an hour. You agree to get me there. It's important, otherwise I'm going to miss my flight. And the Uber driver says, absolutely, I'll be there. Uber driver ends up being late. His whatever fare he had before didn't get done in time, and then late to getting you to the airport. You miss your flight. You have to rebook, and it costs you $150 to rebook your flight. You could sue that Uber driver for that consequential damage of you having to rebook that flight, right? That's kind of, now, the Uber driver had to know. If you didn't tell the Uber driver about any of that, then the Uber driver would not be obligated to pay the $150. But the Uber driver agreed to get you there and on time. That rebooking would be part of that consequential damages, right? It must have been a foreseeable breach, though. As I talked about, the Uber driver had to have known about the condition. And then earlier we talked about Jack and Jill not knowing that Jack had used the money to purchase the house and using the money to pay the mortgage back. Since she didn't know, that there's no way of foreseeing that breach could cause those types of damages, right? That's what I mean by it has to be foreseen that type of breach would cause that type of damage. Incidental damages are the minor costs that injured party might suffer when responding to a breach. It could be because you have to store them, you had to ship them somewhere else, you had to pay advertising costs, whatever it may have been. You may have gotten sued by somebody else because you were now in breach of your contract because you weren't able to get them to fulfill your obligation. Whatever it may be, those are some of the incidental damages that the court would use and also give a party as remedies. Okay. All right, again, kind of reliance interest is where the court is going to put injured party in a position would have been had they fulfilled the contract or never entered into the contract, I should say. If they fulfill the contract, is expectation interest. If they never enter the contract, is reliance interest. A good example of a reliance interest is, I think in the book it talked about an individual agreeing to make 1,000 scarves. So he buys, so we'll call him George. George goes buys materials to make 1,000 scarves, with the understanding that with Macy's was going to give him a section for X amount of time, maybe during Christmas time, to put those scarves in, right? So he was going to sell scarves. Well, he goes, buys the materials,
his time makes 1,000 scarves. We don't know if he would have sold 1,000 scarves or anything like that. It's hard to tell, right? You usually aren't going to sell everything. You may, but not always, right? So in the situation there, what we want to do is, now Macy's comes back and says, you don't get to use that spot. Well, George is out there going, well, wait a second, you promised me that. So the material costs to buy the materials for the scarves, his time, right? If he then had to store them or sell them to somebody else, right? Those are kind of the both reliance, interest costs, and consequential damages that the court's going to use. Restitution interest is designed to return the injured party plaintiff, right? A benefit conferred on the breaching party. We talked about the sort of farm situation in which you make money by not doing anything. That money is going to go to the person who actually owns if you breach your contract, right? Those types of restitution are used a lot in voidable contracts, for fraud, misrepresentation, mutual mistake, duress. Remember the situation we talked about last time where the minor goes in and gets a new car and buys a $2,000 stereo that's going to cost another $500 to have it installed in the car. They then, right, parents find out and like, no, you don't have that kind of money, even though you did it on an agreement to pay them back over the next 2 years. The interest is too high. Parents like, yeah, no, that's not appropriate. Well, the kid doesn't get to keep the stereo and the speakers and everything, right? So the restitution interest is you're going to have to return whatever they put into it. You're probably going to have to pay them for whatever maybe their labor was, but the kid's not going to be on the hook for all the rest of the costs that go along with that particular contract, right? Interest, those kind of things, right? So that's kind of what restitution interest is. You're still going to have to give them back. You don't get to keep it, kid. Sorry, it doesn't work that way as well. That's restitution interest. Quasi-contract damages is unfair for one party to retain the benefit conferred on them, right? That's, again, kind of talking about that situation where I have my property, you agree to pay me, you get $10,000 for not growing, right? Courts can maybe develop a contract and tell you to turn over that $10,000 so that you really maybe didn't have a contract in the first place. That's that quasi-contract that we talked about last time. All right, other equitable remedies I want you guys to remember. Again, go over a little bit more detail. Specific performance, the court requiring somebody to act. Again, this is really done in situations where we're talking about it's a very unique item or very unique situation. Maybe this is the only person that can paint like this, or this is the only person that can build like this, or whatever it may be. Then the court might require the person to fully perform that particular act, to turn over the item for that sale to be finalized, etc. Right? But it's unique. It's got to be something unique. An injunction, court requiring somebody to refrain or to do something. It could be either one, right? In a reformation contract, court will rewrite a part of the contract. If you remember, right, when we had those employment contracts and non-compete clauses, courts use reformation clauses a lot in those non-compete clauses when perhaps it was unreasonable time, it was unreasonable distance, or it wasn't unique enough. The court might just reform that particular provision of the contract to say, all right, yes, this non-compete clause for 5 years is too long. We're going to change it to 18 months. And maybe the district being across the entire state is too far. We're going to make it to this city or something of that nature, right? The court will reform, instead of getting rid of that entire non-compete clause, because there was other good reasons to have a non-compete clause, we're going to just reform it to be more reasonable. All right, some special issues you guys got to remember about mitigation damages. Again, even though the other party may have breached and you're seeking remedy, you still have an obligation before you sue them or as you're suing them to mitigate your damages. You can't just say, well, I'm not going to do anything more. Say you've got 100 bushels of apples and this person agreed to purchase 100 bushels of apples from you, and obviously they'll perish if they just sit there. You can't just sit there and let them rot, right? You need to try and do your best to find somebody else to sell those. You may sell them at a lesser cost. There may be more expenses because you have to ship them farther. You had to advertise them. You're going to get all that money back, but if you just sit there, then the court's probably not going to give you all damages you're otherwise seeking. You have to mitigate what the damages are, right? Nominal damages are where, although you win, you're a plaintiff and you win, and there may be good reasons for you to do some nominal damages, right? And I'll talk a bit about that. But nominal damages is usually where you win the lawsuit, but there's really nothing to give to you, so we're going to give you $1. So to indicate you won, this other person was clearly in breach, and we need to make sure they understand that they're in breach. They can't get away with that, but you really weren't hurt in that situation. Maybe you actually sold the goods for a greater value than you otherwise got. So they were in breach. We don't want to make sure they don't do that going forward, but nominal damages is all you're going to get. And then for liquidated damages clause, again, and we talked about that, it's a specific clause that says, here's what's going to happen if anybody's in breach in this particular contract. On those specific contract provisions, it has to be in the contract at the time the contract was made. It has to be because there would be a difficult time to otherwise estimate what the damages would be if somebody was in breach. And they need to be reasonable, right? Whatever that damage amount was has to be reasonable. And certainly where the courts step in is where maybe consumer goods or something like that, where there's clearly some unequal bargaining power in that situation. Well, you're not going to get your chairs if you don't, I talked about my wedding scenario, right? The courts, it's got to be reasonable. If it's not reasonable, then the courts are going to not necessarily use that liquidated clause. All right. All right, that gets us to the end of this particular video. Here's what I want to make sure you guys understand. Next Thursday is when on Moodle, I'll have a timed test. I'll probably give you guys a little bit more time, but it's still going to be timed. It may still not be as much time as you want, and that's on purpose. And so I apologize in advance, but that's just the way we have to go about doing these new way with the social distancing. I will make sure, if they haven't already been posted, that I get posted some aids for you guys to use. Use your PowerPoints, use the cases in the back of the book to sort of work yourself through how the court's going to look at stuff. Obviously, keep your reading questions and use those reading questions that you have. Anything else out there? I think I got a study guide ready to go, and I'll put it out there. All right, remember, you always can contact me via email. You can call me if you have questions, whatever it may be, before the test. And so if you have something that comes up that you're like, I'm not sure about this particular area, don't hesitate. Send me an email, and I'll do my best to try to better explain whatever that situation is. All right, again, take care of yourselves. Hope everybody's is all good. And if I see you, I'll see you when we see you. Take care.